Morning, members. It is the appointed time, and we have a quorum. At the previous meeting, we have completed scrutiny of clauses 1 to 9 of the Chinese text. Today, we will start with clause 10, that is C2800, and page 26 on the markup copy. Before resuming scrutiny, members, please note that the amendments to be moved by the government has been sent to members. Now, I will invite the government to explain the proposed amendments to clauses 1 to 9 in a moment. Now, in the interim between the meetings, we have received 2 written submissions from the public. They have been tabled before members. If you have any questions, please raise the questions in a moment. Now, I will now invite the administration to come in. I believe the administration has yet to read through the 2 papers as well. So we will now invite the administration to join us. Today we have Ms. Ivy Law, Deputy Secretary, Ms. Wendy Au, Principal Assistant Secretary, Mr. Philip Mack, Assistant Secretary, Ms. Charmaine Wong, Head of the Private Columbaria Affairs Office, Mr. Francis Cheng, Assistant Director, Mr. Jonathan Look, Senior Assistant Law Draftsman, and Mr. Jonas Wong, Government Counsel. Now, just now I've told members 2 public submissions have been submitted over time, but we will still consider them. So concerning the public submissions or any other questions, please press the button. Chair, which public submission are you referring to? The one from Wan Chun Sin Kun? And the other one from Long Life, Long Life. Chair, may I ask a question? Please press the button. Just very briefly, I've read the letters very briefly because of the time. Now, Director Wong from Wan Chun Sin Kun, point 4. He mentioned the $2 million in short-term tenancy waivering fee. That is a very substantial sum. So the director only calls for rationalizing the issue. So is his information correct? Mr. Zhang? Thank you, Chair. Now, for the situation of Wan Chun Sin Kun, it involves sold interment places or niches. Some were sold after the cut-off time. So according to the established policy of the Land Department, for pre-cut-off niches sold, these will be eligible for the exemption of formalization fee. Now, for the 300 niches sold after the cut-off period and the 300 niches unsold, the association needs to pay for the land premium according to the mechanism. Now, the concern is about unfair treatment concerning the exemption period. So how do you view this complaint of unfair treatment? Mr. Zhang? As mentioned in our paper, concerning the exemption or waiver arrangements for land premium, we are consistent. For pre-cut-off columbarium, for pre-cut-off niches, they are still eligible for the exemption. Now, for post-cut-off niches, land premium has to be paid. So the arrangement is consistent for Wan Chun Sin Kun as well, so there is no unfair treatment. Mr. Ho? that's fine, but you need to tell the public that the eligibility for exemption is the same. It seems that there is a misunderstanding that only those niches sold after 2025 would be eligible for the exemption. That is correct. Now the cutoff time has been changed. So some operators think that they are now asked to apply for the license rather than the exemption, because some would prefer to apply for an exemption license rather than the license. Now they have spent so much energy and resources on applying for the license, and now you're telling them there is another option, that is to apply for an exemption. So they have spent additional resources on the license. So of course, from your opinion, you would prefer them to apply for the license. But from their point of view, you have changed the cutoff time, so they wouldn't need to spend so much money on applying for the license from the first place. I think you are, from a legal point of view, everything is fine, but it is not reasonable to the operators. Of course, if the option was made available to them from the very start, the operators would have opted for the exemption routine. So I think the damage done is irreparable. So I think the government should strike a balance between all the factors. May I invite the departments to reach out to the aggrieved parties to sort out the issues of additional resources spent. I know you have been communicating with the aggrieved operators. They know that they are submitting the written submission out of time, but they are very aggrieved about the unfairness. So if members agree, we would urge the government to reach out to each of the cases. Yes, each case involves a few $1 million. Mr. Benson, look. Chair, I'm more concerned about the other written submission, the one from Long Life. Now, the operators of Yanhao Zhongqi or Long Life have reached out to some of our members. So I would like to confirm whether the situation mentioned by them truly exists. The Yanhao Zhongqi is one of the Columbarium operators which made a submission or application to the Town Planning Board to rezone their sites to be in compliance with the land use. Now, the TPB rejected the application from the Yanhao Ancestral Hall based on the same grounds. Now, according to the bill, one of the conditions to apply for exemption is the application has not been rejected by the TPB before. That's why the Yanhao Ancestral Hall thinks it is unfair to them. They would like to be in compliance with the law, so they made an application to change the land use, which was then rejected. So now, for operators which never had the intention to make an application to the TPB to be in compliance with the law, will be eligible for the exemption. So those who abide by the rule is now being discriminated against. So this is their concern. So may I seek a clarification from the administration? Ms. Ivy Law? Thank you, Chen. Thank you, members. We understand the sentiments of the operators of Yanhao Ancestral Hall. Now, this exemption option is an alternative. The law has been implemented for quite some time, and we have seen operators having difficulties in obtaining the license. So considering the overall interest of society and to avoid large-scale ash disposal or clearance option, that's why we offer this new option. True, this option was not available in the early days. However, in face of the difficulties we see, we propose the change. We understand there is a difference in terms of the timing of the option. Now, there are three conditions for the exemption. First, the application is being considered by the licensing board, which have not been rejected. Two, the site must not be in a densely populated area like Hong Kong. Three, the application must not be one that has been rejected by the TPP before. Now, we don't think Columbaria should continue to operate in a very densely populated area like Hong Kong. So that's the ground behind that condition. For the TPP condition, now the TPP would consider whether the land use is commensurate with the planning intention. Now, the TPP is a very experienced authority which would take into consideration of the views of residents. Now, for the application made by Yanhao Ancestral Hall, there was a lot of local opposition. So we did not want to increase the burden on local residents because of our option. In addition, we need to respect the decision made by the TPP, and that's why we put this condition in place. Mr. Look, now we understand the consideration of the administration, and I fully respect the decision made by the TPP. But beyond the case, there may be a scenario where an operator deliberately delayed making an application to the TPP because they know the TPP would reject their application. That's why they procrastinate and wait for today's option. That would be unfair to other operators. Ms. Ivy Law? Thank you. I cannot comment on the likelihood of each application being approved by the TPP. Now, the applicants may propose mitigation measure or reduce the number of niches applied for, and they may get an approval from the TPP then. So I can't say for sure which case will be rejected by the TPP here. Mr. Look, I will follow up on the question with the administration after the meeting. Ms. Dari Lee. Chair, I understand the policy intent of the amendments. I also saw the worries shared by operators from the public submission. Now, our objective is to speed up the regularization of columbarium. So, according to the paper, it is our hope that when all documentations are proper, we hope that the Columbarium office can issue the AIP as soon as possible to the operators so that the issue of land premium can be sorted out soon. Now, the short-term waiver option is very unpalatable to the operators. It is also a worry for the local residents. Now, it is a 7-year lease contract, so that would not reassure the consumers because they would be worried about the long-term operation of the Columbarium. So I think you need to amend or address these concerns. Otherwise, some of the niches may not be able to remain after the cut-off time.
Ms. Law, thank you. We agree that we should speed up all the vetting procedures. As submitted in the last meeting, the PCAO has committed that they will organize the interdepartmental meetings, and we will assign the case managers for each and every applications. I know that the PCAO has already adopted the relevant arrangements, and the operators are positive about all these arrangements. The PCAO will speed up their vetting procedures. As far as I understand, the operators cannot talk to the lands department about land premium if their application is not approved. Can you speed that up, Mr. Chang? Thank you, Madam Chair. I thank Dr. Lee for the question. Regarding lands premiums application, if there is any violations to the lease conditions, then the application have to be approved before any other procedures can be taken forward with the lands department. We will follow up on that with the lands department. I hope that you will allow the applicants to apply with the lands department to go forward with other procedures, because each and every step takes a long time. That's my first comment. Second, what about the short-term waiver? Have you received any complaints from the trade or the members of the public? Deputy Secretary, thank you. Regarding the short-term waiver arrangement, this is an established policy of the Lands Department. They charge a waiver fee once every year. We hope that when the Columbaria operators sell their niches, they will not exceed the maximum amount allowed to protect the consumers. But the number of niches have nothing to do with the 7-year limit. If operators choose the 7-year waiver, is that in conflict with the permanent niche? I can try to answer the question. As far as I understand, regarding the land premium, operators can pay that in 10 years. Regarding the 7-year short-term waiver, I will ask the PCAO to supplement. Thank you, Dr. Lee, for the question. If the operators have not violated any of these conditions, they don't have to apply for regularization. If there is no illegal occupation of government land, and if there is no breach of these conditions, then they don't have to apply for regularization. But some operators actually have breached these conditions. Say, for example, they may be occupying government land illegally, or they have breached the lease conditions by placing niches illegally. Under such circumstances, government allow for regularization applications to allow the operators to address the issue by issuing them with a short-term waiver. The validity period of the waiver is 7 years. Within the 7 years, the operators have to submit or pay rent to the government every year. The reason why the operators can sell the niches that last for 1 year is because they only pay rent to the government once a year. That's why there's such a limit. Now we have been talking to the relevant operators to see how we can relax the arrangement. I hope that you will pay attention to this concern, because I find it very reasonable. Next, Mr. Paul Chen. Regarding the two submissions, the Wan Chin Sin Kun has made a number of points, and I'd like to follow on the question about Yan Hao Ancestral Hall. The planning departments update their policy from time to time. I don't find it reasonable to reject an application from an operator that have their application to the TPB rejected. I think that we have to look into the reasons why the rezoning application was rejected by the TPB. We should not prohibit someone from applying for a visa just because they have been rejected in the past. The example quoted by Mr. Look is something that we should look into. Some operators try to apply for a waiver, and just because their application was rejected, they cannot apply for it again in the future. I think that we are punishing those who try to abide by the law. And this is exactly the case of Wan Chin Sin Kun. This is unfair to those who obtained a license early on. It gives the impression to the trade that we are letting those who don't abide by the law go. I don't think that this is fair. I know that we are in the stage of legislation, but given the abundant submissions that we have received, it seems that we need to amend the bill to make things fair for those who have already obtained a license or for those who have their rezoning application rejected by the TPB. Thank you. Ms. Law, thank you. Let me clarify. We are not saying that the operators will not fulfill the conditions just because their applications were rejected by TPB once. It's okay if an applicant has their rezoning application with the TPB rejected once, they can still meet the conditions, and we have approved such cases where an applicant have their rezoning application rejected by the TPB but approved later on. Just as I mentioned, they can put in place mitigation measures or reduce the number of niches in order for them to have their rezoning applications approved by the TPB. And once their applications have been approved by the TPB, then they will meet the PCAO's requirements. And we have set that out in the paper. Thank you. Mr. Chair. I don't want to dwell on the number. It seems that as long as someone has their rezoning application rejected, then they would not meet the requirements. Am I correct? Mr. Che's understanding is correct. As I mentioned, for the Yan Hao Ancestral Hall's case, as I mentioned, the applicant, if their rezoning application is rejected by the TPB, they will not be eligible to apply for PCAO, because if their application is rejected by the TPB, usually there was strong objection from the nearby residents. That's why we put in place such a condition, Mr. Chair. According to the submissions of the Yan Hao Ancestral Hall, there were only 6 households who objected to their rezoning application. So it seems that there were not that many people objecting to the rezoning application of the Yan Hao Ancestral Hall. The Deputy Secretary just said that as long as an applicant has their rezoning application rejected by the TPB, then they will not be eligible for a waiver. Compared to those who never filed any application, with a clear record, they will be able to enjoy a waiver from the PCAO. So as long as you have filed an application with the TPP and have your application rejected, you will be disqualified. Deputy Secretary, regarding the number of objections received by the TPP, we saw that there were over 600 objections received with the case of Yan Hao Ancestral Hall. Some operators are more laid back. We don't think that this is the right description. Operators have to have regards to their own situation before they can file an application. So they act in accordance with their situation before making any business decision. Mr. Chang? No? Mr. Chair. I don't want to dwell on the wordings. The word laid back may be rather casual. I'm not trying to offend operators who have not filed any application before. So please don't just address the word that I use instead of answering the question. The point is that this is unfair. For those who have never filed any application, then they will enjoy a waiver. Am I correct? Deputy Secretary, I fully understand Mr. Chair's point of view. Now, we have to address an historical question, and we see that some Columbaria cannot meet the licensing conditions. That's why we propose this idea of an exemption. And we need to set suitable requirements. For Hong Kong, densely populated area, we need a relevant conditions to address that, and we think that we should respect the TPP's decision. That's why we include that as one of the conditions for application of exemption. Individual Columbaria may decide not to make an application because of their situation. The goal of this piece of legislation is to offer a choice for operators, and we think that we need to set suitable conditions to protect the interest of the society. That's our intent. Thank you. Next, Professor Chen Wing-Kwong. Thank you. I've read the two submissions. I think that we have to be fair. And if the legislation is unfair, then this will give rise to problems. So it seems that operators who have never filed any application enjoy a waiver, an exemption. And for those who have filed an application before, they won't be able to enjoy an exemption. This is unfair. So I think that from the perspective of the community, principle of fairness is very important. If we don't act fairly and justly, it would be meaningless for us to scrutinize any bill in the Legislative Council. The most important thing is that you address the issue of unfairness. Thank you.
I will defer the question to Mr. Zhang. Thank you. The concerns raised were whether some operators eligible for the exemption were laid back during the earlier days. Now, actually, Columbarium operators need to convince the licensing board that they have a plan to obtain a license. They need to have a timetable for obtaining the license. So according to the paper, there are 38 columbariums which are eligible for obtaining the license at present. 25 of them have received planning approval according to the land use. And for the remaining columbariums, they are now in the process of discussing with the planning department on how to make their operations compliant with the land use. So all those columbariums eligible for the exemption have taken action to address the issue. Now, to apply for a license, you need to fulfill or comply with the planning intention of the land. Professor Chen? But there are still 13 columbariums which have not received an approval or rejected by the authority yet. So supposedly there are some operators who would have been rejected provided that they have filed an application. And there are also operators who have already filed an application and rejected. So that is not fair. So there should be a mechanism to give the operators who have had their application rejected a second chance to be eligible for the exemption. There should be a mechanism which is fair for everyone. You can't deprive the columbariums which have had their applications rejected of an exemption. Deputy Secretary. Thank you, Professor Chan. Our focus is on the public interest as a whole. Now, if the TPB has rejected the application from a columbarium, and then we provide another avenue for the operator to have a second chance, is that fair to the local residents? So besides considering the concerns of the columbarium operators, we also need to pay attention to the local residents and society's concerns. Now, my point is on the principle of fairness. You are still talking about before and after. I'm saying that you are not fair to those operators who have filed an application and were rejected by the TPB. So this batch of so-called eligible operators would have been rejected if they had applied for an approval from the TPB. So they would not be eligible for the exemption still. So it is not fair. Deputy Secretary, I understand Professor Chan's concern. But should we scratch the exemption mechanism and exacerbate the issue? I don't think so. So we would still want to amend the legislation and avoid the scenario of edge clearance. I think we are talking cross-purpose. I'm talking about the principle of fairness, but you fail to address my concern on fairness. According to your policy intent, everyone is equal before the law. If we can't talk about the principle of fairness in electrical, that would defeat the purpose of us council members. You can't measure the same issue with two yardsticks. You are not treating those who have tried their best to comply with the law fairly. If you're not treating the parties fairly, how can we convince citizens to respect the fairness of the framework? Now, if the administration is depriving the opportunity of operators to an exemption because their applications were rejected by the TPB, that's in the case of Yanhao Chi. The operation is located on a village environment. Now, because of changes in society, we are now allowing more developments on V zones. So in the past, these cases were rejected. However, in accordance with the latest developments of society, including the Northern Metropolis, the government may need to reconsider providing more discretion, offering more discretion to these columbarium which have been rejected by the TTP. Although they may not be eligible for the exemption, the government should compensate these columbarium operators to address the unfairness caused to them with the latest legislative amendments. Now, I agree that the change to the cut-off time is unfair to those operators which had begun preparing to apply for a license. So the government should compensate these two groups of operators on two levels. Now, of course, I agree that with our densely developed urban areas, we need to reconsider the location of columbarium. But there is unfairness in front of our very eyes. We need to support those aggrieved operators to continue to operate fairly. I think that's Professor Chan's point. So will the government reach out to Yanhao Chongqi and Wanqun Xinkun? These are the aggrieved columbarium operators. Can you explore with them how to balance their interest and make it fair to them in terms of the license fee and license conditions and so on? Now you can, if you read the submission from Yanhao Chongqi, there is another columbarium, Hao Xiyun, off the road. It is also on Visheng. They share an access. So why are you allowing the application from one operator but reject the other? Should we really link the eligibility of this mechanism with TPP? If TPP says no, then the operator will not be eligible to the exemption. So I share Professor Chan's concern. Yes, we do respect the decision of TPP. But on the other hand, we need to consider the application from the point of view of urban development. When were these applications rejected? Do we need to reconsider the application? Now for the case of Yanhao Chongqi and Memorial Park, Hong Kong, so the major ground for rejection is the V zone. So it is not so much about objections from the local residents. So maybe it's about the number of columbarium niches that they applied for. So it is about time we consider the fairness of the whole deal. So I think the administration needs to address the grievances of the aggrieved parties. Professor Chen, do you agree with my interpretation? Yes, very fair, thank you. Ms. Jovi Chen. Thank you, Chair. I echo Professor Chen, Mr. Jie, and Mr. Luke's concern about the fairness of the cases, especially Yanhao Chongqi. They fully cooperated with the government from the very beginning, but now they are put at a disadvantage. Now, according to the TPP's documents, they want to avoid setting undesirable precedents. But now we are amending the law, and we are seeking changes. The government would like to avoid large-scale ash disposal. Now, if the operators are legit and honest, this is exactly what they want to avoid. So that should be an exceptional, there should be an exemption mechanism to allow them to continue to operate. Now we are putting those who cooperated with the government at a disadvantage, and that is not ideal. Now, on the point of large-scale ash disposal, that is exactly why we need to be flexible. We need to set a precedent which is agreeable to both the government and the public and the operators. Now, in the process of our scrutiny, many stakeholders have put forward their views, so we should consider and take on board their views, rather than making it a fast and hard rule that if the application has been rejected by the TPP, they would not be eligible for the exemption mechanism. So it is a rare case where there is a consensus across the political spectrum that the government should reconsider the mechanism. We need to provide clarity to the businesses. Ms. Ivy Law, thank you, Chair, and thank you, members, for your views. We've heard members' concerns on the condition. Now, I would like to emphasize that application for exemption is just an option. Now, for cases rejected by TPP, the operators can still apply for a license. The exemption pathway is just an additional option. Now, concerning the decision process of the TPP, that process is a very sophisticated process. The TPP would have considered all views before reaching a decision. So I have no further supplement. Mr. Benson Look, the second round. Thank you, Chair. Just a moment. I will invite Ms. Jovi Chan to finish first. Please switch on Ms. Jovi Chan's microphone. Thank you, Chair. My apologies. Ms. Rebecca Chan. Sorry, I was in another meeting. Now, about Wan Chun Sin Kwun situation, the letter raised a number of questions which seek an answer from the administration. First, Wan Chun Sin Kwun has made an application for a private columbarium license according to all the rules. Now, the exemption period now is the 30th of June 2017. However, for those who have complied, who have been cooperating with the government, at the very beginning, their exemption period was 18th of June 2014. If you are amending the law, shouldn't you make the exemption periods consistent? Why were the exemption period for the earlier applicants the 18th of June 2014? Now, after the amendment to the law, there will be two different exemption cut-off days, and it would be unfair to some of the operators. And also, according to Wan Chun Sin Kwun, they did not generate a revenue all along. They need to pay a sum of $2 million each year for the short-term tenancy exemption. Now, we are not the one to say what the business of Wan Chun Sin Kwun is. They are a Taoist organization which offers columbarium service. It seems that we are imposing the definition of a commercial operation on Wan Chun Sin Kwun. Now, since there are so many concerns, we really need to address and answer the questions raised in these letters, before continuing. Otherwise, it would be improper.
Deputy Secretary. Thank you, Ms. Chan, for the comment. First, regarding the period of exemption. There could be a misunderstanding on the use of words. The PCAO has talked to the operators of Wanchen Sin Kun. They wonder if we are going to offer land premium waiver for niches between the 18th of June 2024 to 30th of June 2017. We are not going to waive their land premiums for niches sold with a license or with an exemption. We're going to waive land premium for those that are sold before the pre-cut-off date, whether the operators hold a license or an exemption. So there is consistency, and this is fair to all operators. Previously, the eligibility criteria for exemption is that operators should not have sold any niches before 2016. That's because we saw that operators applying for a license due to various reasons could not apply for it, and that's why we relaxed the requirements. It seems that there is some misunderstanding. We have just amended the eligibility criteria, not the amount of land premium. Second, Wanchen Sin Kun said that since they obtained a license, they have not generated any revenue. Now they are a licensed Columbarium operators. As to whether they can sell any niche, there are various reasons to why they can or cannot. Let me give you some information. Similar operators have sold during the period over 100 niches after obtaining a license. So this is particular to this operator. You said that you have explained to Wanchen Sin Kun about the exemption period of, say, 2017 and 2014. How come Wanchen Sin Kun still thinks that this is a wrong decision? Can we make it consistent? If you have explained to the Wanchen Sin Kun, why are they still submitting this letter to us? Are they still not clear about the exemption? I will ask Mr. Chen to supplement. Thank you. Last week, we've talked to Wanchen Sin Kun about the letter. We have explained to them that the exemption is for waiving the requirements of a specified document instead of waiving them of regularization fee. Some operators don't understand. They thought that they would be waived of the regularization fee because of the exemption. These are two separate policies. The regularization fees are charged by the Lands Department for specified documents of a licensees or exemption holder. If you obtain an exemption, then you don't have to meet the planning requirements. And as a result, they don't have to file an application with the TPB and they can operate as is. So the requirements for the exemption has changed. We have delayed the deadline because we saw that some license applications may not be able to meet the requirements and there could be large-scale ash disposal as a result. For applicants that cannot meet the 3 requirements of exemption, what can they do? Well, for these 10 operators, they can apply for a license. The rights to obtain a license has not changed, and we have not tightened any restrictions. Thank you. Thank you. Next, Mr. Benson-Look for the second round. Thank you, Madam Chair. I'd like to follow up on the point about operators not being able to apply for an exemption after the application was rejected by the TPB. I have a few questions. Many members quoted the Yanhao Ancestral Hall's example. For operators who have their application rejected by the TPB, under this bill, they are not eligible for an exemption. So this is not an option for them. So they have two options left. One, ash disposal. Second, try to file another planning application with the TPB. That's my first question. Second, the Yanhao Ancestral Hall said in their letter that the Transport Department have no problem with their application. They said that their application was rejected because of the many objections from the nearby residents. Now, coming back to this bill, how can we cater to the interest of the nearby residents? Do we have a mechanism to address the issue? Some operators work on, say, their design to cater to the need of the nearby residents, to make the Columbaria more in harmony with the neighborhood. So the TPB has to take into account the interest of the nearby residents. Third, I agree with the chair's suggestions. I hope that the administration will reach out to these operators in order to address the concerns that they have. Thank you. Deputy Secretary. Thank you, Madam Chair. Thank Mr. Look for the questions. First, upon passage of the bill, if the operators still haven't had their application approved by the TPB, they can still go ahead with the license applications with us. They have to amend their application in order for the TPB to approve their rezoning application. Well, working on the design is one way to gain the support of TPB. Reducing the number of niches is another. Regarding the Yanhao Ancestral Hall case, we've looked at the minutes of the TPB. The TPB had taken into account the zone situated, that is the V zone, where the Columbaria could be situated at. So the board has to look at the compatibility of the land use and the planning's intention. The member said that we should reach out to the applicant. We agree with that, and the PCAO is going to follow up on the applications with them. Madam Chair, I was asking if there is any way for us to have regards to the interest of the nearby residents when we are, say, scrutinizing their applications for license or exemption. Thank you. Deputy Secretary. Thank you, Madam Chair. For all applications of specified documents, the licensing board take into account the views of the residents. There is such a mechanism. Next, Mr. Paul Chair for the second round. Thank you. I commend Madam Chair for your summary because you have made a great conclusion of our discussion. Just now, Ms. Chovy Chan, that we had reached a consensus, which is very rare. I know that the administration have to balance the interest of various parties, but today we have to focus on inter-industrial or intra-industrial interest. Just now, the Deputy Secretary have given their reasonings as to how we can strike a balance between the interest of the residents and the trade. But what about the intra-industry interest? I think that you should perhaps set a more relaxed restrictions or requirements as long as the Columbaria is a pre-cut-off fund, they can apply for a license or exemption. You should perhaps abandon your requirements on, say, not having been rejected by the TPP in the past, so that we can cater for the interest of the trade. You said that for those who are not eligible for exemption, they can apply for a license. I have a technical question. Will the operators be violating the law if they are not able to apply for exemption and they have yet obtained a license? What happens when their license has not been approved? Are they then operating illegally during the period? Third, should we delay the timetable? Perhaps you should look into withdrawing it and reconsider the content. You can withdraw the bill. Thank you. The operators will not be breaking the law. I will ask the PCAO to elaborate. Thank you. Under existing legislation, we do have a waiver period for pre-cut-off Columbaria as long as they are applying for a temporary suspension of liability. They can still operate even before obtaining a license or an exemption. Yanhao Ancestral Hall is applying for a license, and they also are applying for a temporary suspension of liability. That's why, in the meantime, they are operating illegally still. So they were not breaking the law. What about the point about intra interest? Can the Deputy Secretary give us some insight? Thank you, Madam Chair. I think that we have explained about the government stance. The exemption is an extra option for the industry in order to cater to the difficulties that we have been facing since the enactment of the ordinance. And we think that there should be conditions. And as long as there are conditions, there's bound to be someone who cannot meet the condition. Some operators will meet the conditions, some will not. That's only natural, and we think that the conditions are appropriate. We intend to keep all the conditions.
Sorry, just a brief follow-up. Now, your main objective is to avoid ash disposal or clearance, and also you want to uphold the principle of fairness. That means balancing the interests of parties. Now, if we move committee stage amendments to your bill, will you think that we are hijacking your bill and withdraw your bill? I fully respect any actions taken by council members, and the government is not in a position to comment on legislative actions. For our bill, of course, we consider it the most appropriate option to balance interests of parties and also achieve the objective, that is, avoidance of large-scale ash disposal actions and address the public's concerns. So we do think that the bill has its merits, and we urge members to support the bill. There are no other members. I also have a few questions concerning the issue of exemption or waiver period mentioned by Wan Chun Sin Kun. Now, previously, the exemption period was up to year 2014. Now you are amending the cut-off time to 2017. So I think Wan Chun Sin Kun would like to have the exemption period extended to 2017, and then all those episodes in between would be null and void. So can you amend the exemption period for earlier applicants to 2017 to align with the new mechanism? If that can be done, if the original exemption period can be revoked and changed to a later one, that would address all the problems. Now about the exemption period. The exemption period for new applicants is just a condition for an addition on the document. Now for the period between the 18th of June 2014 and the 30th of June 2017, the waiver fee is the same. We have not exempted the fee in between. Whether we can offer waiver to niches sold in between. Now for pre-cut of Columbarium, many of them, or 60% of them, have not sold any niches in the interim period. Now for the small number of niches sold in the period, there were some 10,000 such niches. The operators have charged a fee from the consumers, and they need to fulfill their responsibility as an operators. This is a responsibility to be borne by the operators themselves, and we don't think it is appropriate to subsidize the operation with public money. Now, if operators fail to apply for a license, they can resort to the exemption pathway. But if niches were sold, they still need to pay the premium. If not, they don't have to. Now, we don't know the number of niches sold by each and every of the columbarium operators. We don't have that information. So it seems that by extending the exemption period, it would be beneficial to them. Now, their original exemption period was year 2014. Now, since extending their exemption period would not jeopardize the benefits of the interest, why don't grant that exemption to them? It doesn't matter whether niches were sold in between. So according to the paper, it seems that their only request is to have their original exemption period deferred to 2017, and they would handle any matters arising from that. Can that be done? Now, about extending the exemption period to the 30th of June 2017, it seems that the operators would like to enjoy the waiver on land premium until the 30th of June 2017. It is not about the fee for applying for the temporary suspension of liability. Now, as I said, among the columbarium, 64% of them have not sold any niches. For those which have sold niches, they have earned a profit from the sale of niches. Now, if we offer land premium waiver on these niches sold, that would be unfair to columbarium operators which have not sold any niches in the interim period. And that would also cost a lot of public money. So we will not waive the land regularization costs on these operations in the interim. Now, since we are extending the cutoff date to the 30th of June 2017, for those operators who have already obtained a license, this option would be void to them. Now, if you look at the letter, they have been talking about the $2 million waiver fee. They're not talking about whether niches were sold. Now, they say that they don't have niches to sell anymore. They can only charge the rent of the niches every 10 years. So by extending the waiver period, you are just talking about the land premium waiver period. For Wangchun Sin Kun, they cannot sell niches anymore because according to the condition, they cannot sell any more niches and they are only allowed to lease the niches and charge the rent every 10 years. So in terms of amendments, we would like to give you the flexibility to amend the law yourself. Can you add a condition to give you some flexibility that you can exercise discretion to approve the license application? Would that be a more ideal way to go, since you can keep the power to decide? May I defer to the PCAO? Mr. Chang, now for Wangchun Sin Kun, there are two categories of niches which requires premium payment. First, niches sold between 2014 and 17. That's niches sold before the ordinance has taken effect. So we're talking about 369 niches sold in the interim. Now, since Wangchun Sin Kun has made an application for license, Wangchun Sin Kun was allowed to sell niches after a license was granted. So there were 358 niches in that category. So together with the total number include 368 plus 359. In total, 700. So the Wangchun Sin Kun has to pay premium for the 700 niches sold. That is a different option compared with the exemption avenue. That is just a waiver for land plan requirements, but not the premium. There is an established mechanism to deal with cases in breach of short-term tenancy conditions and land use planning. So under these established mechanisms, the short-term tenancy or the waiver would last for 7 years with premium paid. Thank you. Third round, Mr. Paul Chen. Once again, I thank the chairperson for your summary. You have summarized our opinions very concisely, and that it would be better if the government moves a CSA themselves. Now, rising from the previous reply, I believe that some operators have a point by raising the unfairness. There must be a difference in terms of profit to them. Now, I hope I didn't understand the PCAO wrongly. when there is a cut-off time. Now, for the 359 niches sold after the cut-off time, did the operator have to pay a higher premium? I don't know, because that is a very technical matter. But given that the Wan Chun Sin Kun has made a protest, I think there must be a difference in terms of profit. So I think it is unfair to some operators. There is intra-industry unfairness. And also, you assume that the earlier applicants had generated profits from niches sold, so it would not be unfair to them. So my question is, if an operator has sold one niche, does it mean that they are not eligible for the exemption anymore? Is this a cut-off criteria? Now, it would be very unfair for law-complying operators which have sold one or two niches in the interim. I really think that the reason why there are so many opposition from the stakeholders is that the proposal is unfair. Deputy Secretary. Thank you, Chair, and thank you, Mr. Jie. And concerning the land regularization fee, we would look at the number of niches sold. Now, if only one or two niches were sold, the land regularization cost must be much lower than those operators which have sold a lot of niches. So there shouldn't be unfairness. Mr. Jie, please be focused in your answer. I'm not saying about the potential number of niches sold. I'm focusing on the actual number of niches sold. You are assuming that the columbariums have sold a lot of columbaria, but maybe the number is very small. It is not very profitable. They don't have a lot of niche spaces available for sale. That's why they are so concerned about the cut-off time. Mr. Zhang. Now about fairness for the case of Wan Chun Sin Kun. When the Wan Chun Sin Kun applied for an exemption, now for the 369 niches sold between the cut-off time and the extended cut-off time, they still need to pay a premium. Now for operators which opt for the new option, if niches were sold in the period between the cut-off time and the Gazetted time, they still need to pay the premium. So the arrangement is the same. Mr. Jie. Now let me say this. I believe the Wan Chun Sin Kun has requested further meetings with the government with council members present. But I believe it is very difficult to have a public hearing in the council. So let's meet with Wan Chun Sin Kun beyond the council setting and explain and discuss with the Wan Chun Sin Kun on how we can offer additional help to them beyond the scope of the bill. Deputy Secretary, yes, that is definitely viable. So there are no further questions. So before we resume clause-by-clause scrutiny, the government will move CSA. So will the government please explain to us the contents of the CSA? Clauses 1 to 9.
主席，
Madam Chair, can we talk about our CSAs during the clause-by-clause scrutiny? Can we complete our clause-by-clause scrutiny before we talk about our CSAs? Please cover the CSAs first. Because we have completed our scrutiny of clauses 1 to 9, members are aware of the content. So please brief us of the CSA before we start the clause-by-clause scrutiny again. Thank you, Madam Chair. Members may refer to CB bracket 3, 395/25 bracket 01. There are 4 proposed amendments in clauses 1 to 9. Let me first talk about the first amendment. Clause 6. That is, we're going to make a technical amendments to the proposed new section 28 bracket 5 to include references to section 38 and 104 bracket 2 bracket D to clearly reflect that the provisions cover interment rights sold before the enactment date upon the commencement of this bill. Yes? Any questions? Please move on. The next amendment is related to the new section 28, and we have adopted the legal advisor's advice, and we are going to amend the existing section 26 bracket 1 bracket B to include reference to the new section 28 to clearly reflect the licensing board may grant application made in reliance of the said new section and authorize to permit the particulars specified in section 26 bracket 2 as shown in the plans. It's about the plans. Any questions? If not, please proceed. The next one is the technical amendments to the proposed existing section 27 bracket 4. We're going to include reference to new section 28 to clearly reflect that the definition of eligibility related provisions under section 27 bracket 4 covers application for exemptions made in reliance of the new section 28. Any questions? The fourth amendment, please. The next amendment is a technical amendment to the existing section 40 bracket 2 bracket 4 to include reference to new section 28 to clearly reflect that the said existing section covers exemption granted in response to an application made in reliance of the new section 28. Regarding the bracket 2, what does it really mean? Because Section 18 is about licensing application, Section 19 says that under certain circumstances, if the applicant can offer evidence to the satisfaction of the licensing board, then the licensing board may grant the application. Any questions? The fifth amendment, please. The next one is a technical amendment to Section 84, bracket 1, bracket 8. We are going to include reference to new Section 28 to reflect that the rights to appeal under Section 84 covers a refusal of an application for exemption made in reliance of the new Section 28. Any comments regarding the CSAs? No? If not, let's go back to the clause-by-clause examination. Let's start with Clause 10, that is C2801 of the Blue Bill and page 26 of the marked-up copy. Thank you, Madam Chair. Clause 10 is going to increase the penalty for non-compliance with enforcement notice. We're going to increase it from level 3, $10,000 to on summary conviction to a fine of $500,000 and imprisonment of 6 months, or on conviction on indictment to a fine of $5 million and to imprisonment for 2 years. Yes, any comment regarding the penalty? Mr. Tony Che. Thank you. I'd like to know more about the CSAs. That is shares of niches. In Part 3, Clause 8, 8 bracket 2 bracket A, B, says, well, talks about the capacity of the niches set out in the plans. I wonder how it is illustrated on the plans. I know that you will indicate the locations and the number of niches on the plans. Is that how you illustrate the capacity? Because we've talked about the interment capacity. The administration has given a clear reply, so I'd like to know about how the ash interment capacity is shown in the approved plans. Apart from location and the number, what information are you going to see on the plans? That's my first point. Second, regarding penalty. There are two parts to it. First, on non-compliance with enforcement notice. The level of penalty has been set out in the bill. If the operators don't comply with the requirements, let me go back to the Chinese version. I wanted to talk about the penalty. Enforcement notice. There is a fine of $500,000. And there is a penalty of $2 million for offense relating to the sale of interment right without authorization. I wonder why the penalty level is different for these two offenses. Because there is also another penalty on non-compliance with ash interment capacity. I'd like to know why there is two penalty level of $500,000 and $2 million. For Section 54, for non-compliance of ash interment capacity, there is a penalty level of $2 million. For non-compliance with enforcement notice is $500,000. You like to ask about the difference in the fine level. Is that right? Yes. Deputy Secretary. Regarding the ash interment capacity, I will ask the PCAO to address that. The penalty level is different because we think that the gravity of the offenses is different. Regarding enforcement notice, it covers many things. It could have something to do with the record keeping, the management situation, the cool-off period, and we think that the penalty should be lower. So the maximum penalty is $500,000 and imprisonment of 6 months on summary conviction. On conviction of indictment, then there will be a fine of $5 million and imprisonment of 2 years. I will ask the PCAO to supplement. The unit of niches set of ashes. the capacity regulate the operator. That is how many sets of ashes can be interred. Say, for example, there are 10 niches in a Columbaria, and in each niche there can be 2 sets of ashes. Then the ash interment capacity of the Columbaria would be 20 sets of ashes. Ash interment capacity is an important figure, and it will be shown on the approved plans. So what information will we see on the approved plans? There will be a layout, there will be drawings of the niches on each and every story of the Columbaria, and there will be a list of niches and the number of sets of niches that can be interred in a single niches. And the total number of ash that can be interred will be set out also on the approved plan. The operators, once they obtain a license, would be aware of the ash interment capacity because the plans would have been approved by the licensing board. When the operators sell the niche, we ask them to set out in the interment contract the location of the niche and the sets and the number of sets of niches that can be interred in that niche, so that a purchaser know about the capacity of the niche that they purchase. Madam Chair, I have something to clarify. I think that you are talking about the approved plan, and the plan has to be approved by the committee, not the government department. Am I right? Yes. Mr. Chair also asked about the interment right and capacity. I think that we've discussed this in previous meetings. Deputy Secretary, do you have anything to add regarding the sets of niches that can be sets of ashes that can be interred in a niche? Are you going to change the wordings? Thank you. In the last BC meetings, we talked about the words of sets, shares, and so on. And we've asked the trade if they find it difficult to understand. After the last BC meeting, the PCO reached out to over 10 operators. They think that the wordings are clear to them. Now, in terms of ash interment capacity, we're talking about the number of sets of niche ashes that can be interred in a niche. For niche with ash interred, then we use the word shares. So we think that is clear. Any follow-up questions? If not, please move on. Clause 11. We're going to introduce a new section 99A to introduce a new offense relating to the sale of interment rights without authorization or when authorization has been revoked or suspended. 99A. Level of fine, $2 million, $5 million.
議員，多謝主席。我想
Mr. Tony J. Thank you, Chair. Just a clarification. 99A. It says the holder of a license in respect of a columbarium first of all without an authorization or when the authorization has been revoked or suspended, when niches are sold under these conditions, then there would be a penalty. So that's a penalty on the holder of a license, right? Now the English version says the holder of a license without an authorization. So will that affect the eligibility of the licensee to hold the license according to the law? Will they still be considered the license holder because a condition has already been breached? So these are two different scenarios. For the first scenario, without an authorization, a license has been obtained, but because of the breach, the authorization will be suspended or withdrawn. So is the licensee still considered a licensee? Deputy Secretary, thank you. I will defer the question to the PCAO. Mr. Zhang, the offense targets the holder of a license. After the issuance of a license by the licensing board, the licensee will be authorized to operate or even sell niches. So the licensing board is empowered to, under certain conditions, revoke or suspend the license, or temporarily prohibits the sale of niches. So these scenarios have not occurred since the legislation has taken effect. But we are providing for these scenarios. Let's say a licensee's authorization to sell niches has been revoked or suspended by the licensing board, but the operating right has not. It means that the operator can still operate the columbarium. However, if the licensee still sell a niche, that would be in breach of the licensing board. However, under the existing legislation, there is not an offense for this breach. That's why we want to provide the penalty for this breach. I think I didn't make myself clear. I understand that this is a penalty for selling niches anyway, even when the authorization is revoked. The operating right has not been revoked. So the revocation, suspension, and temporary prohibition of the right to sell niches will not affect the license itself, right? The operators can continue to operate the columbarium despite the selling right has been suspended or revoked. So by selling, it means selling additional niches. So if the number of allowed niches in the columbarium remains the same, that would be fine. So the operating right of the licensee will not be affected. Is that right? Your offense targets the license holder. So will these conditions render the license invalid from a legal point of view? Yes, rules have been breached, but will that affect the validity of the license? So I hope there is clear guidelines for the law enforcement. The offense should not affect the validity of the license. Mr. Chang, I will take the question. Thank you, Chairperson, and thank you, Mr. Jie. In short, Mr. Jie's understanding is correct. The license holder is still a license holder. However, the rights or the authority to sell niches has been revoked or suspended. So if a niche is sold under this situation, the operator would be in breach of Section 99A. Now, for more serious offences which warrant revocation of license, there is another section, that is Section 40. So for the purpose of this session, Mr. Jie's understanding is correct. I think Mr. Jie's question is, if there is a breach of condition, should the license be revoked as well? Is that what you mean, Mr. Jie? No. The provision says without an authorization. So is there a scenario where niches are sold without authorization? So can you target the offender with this offense and penalize them? So selling of a niche without a license or without an authorization. Deputy Secretary, thank you. So there are two aspects. One, the licensee is still a valid license holder. If that's the case, then we would invoke Section 99A. However, for whatever reasons, if an operator is operating or sell niches without a permit or without a license, then under clauses 10 and 11, there are offenses for selling niches without a specified instrument, that is $2 million in fine and 3 years of imprisonment. For indictment, that would be $5 million and 7 years of imprisonment. That is a very heavy imprisonment term. So there are different sessions to deal with different offenses. Understood. Thank you. So there is a difference. So this session only targets a license holder who sells an internment right while the authorization is revoked or suspended. So for other, more serious offenses, there are other sessions which deal with them. Thank you. Thank you. Part 4. Part 4, Clause 12, amending Section 87 of the Ordinance, stipulating that the appeal board may, upon special grounds being shown, receive and consider any material that has not been made available to the licensing board before the decision on the appeal was made. Now, the new requirement will apply to appeal cases filed after that the amendment bill has come into effect. So adding sections 2A and 2B. Any questions? The appeal board may, upon special grounds being shown, receive and consider new materials. Mr. Tony Jie. Just a brief question. So the administration has explained what special grounds are. So who would be the party to raise these special grounds? Will it be the applicant or the licensing board or the appeal board? The applicant will have to raise these special grounds. Mr. Jie? No further questions. Thank you. I have a question. What are some examples of special grounds? Now, there are 3 elements under the common law principle. First, the new material cannot be obtained through reasonable endeavor submitted to the appeal board before the appeal. Second, the new materials may have a major impact on the outcome of the appeal. 3, the new material must be prima facie credible. So do you need to put these factors into the bill? Because I have questioned what special grounds are. Now, under the common law rules, according to the DOJ, there will be new developments according to new precedents. So we don't think we need to spell out these factors. Now you say the board may receive and consider the material. So the appeal board may choose not to receive and consider these material, right? I will defer the question to DOJ. Mr. Jonathan Look. Yes, we use the word may and special grounds because under the same context, other ordinances have used the word special grounds as well. There is a precedent in 1956. The precedent is widely adopted in courts in Hong Kong. Now, my colleague has mentioned the three grounds or the three factors. So according to our interpretation, special grounds would cover the three grounds mentioned above. So in order to maintain consistency between this ordinance and other existing ordinances, we resort to the term special grounds so as to invoke the relevant precedent. Thank you, Chair. Any more questions about 2A and 2B? We move on to Clause 13. Part 5. Part 5, Clause 13, amending Section 5, brackets 1 of the ordinance to improve the expression of the provision. There is no material change to the arrangements. That is, no person may pay worship or offer ritual offerings in the workplace to any deceased person. Clause 14, introducing a new 5A so that eligible masons' workshops may store ash urns temporarily when necessary. So these arrangements are the same as the existing arrangements. For example, the set of ashes can be kept for no more than 14 days, and the purpose of the storage is for mason works, and also no worship must be offered to the ash, and also a register of the delivery of the ashes and the removal of the ashes must be kept for inspection, and the masonry workshop cannot sell the stored ash urns. Any question about Section 5A? Dr. Junius Ho, I'm just curious. No worship must be paid in the workshop. Now, sometimes the descendants are really filial. So what if they move the ash urns out of the workplace and pay worship to the urns? Will the masonry workshops operators be held accountable? Now, this is a public place outside the mason's workshop. Sometimes there is a photo table for the family members to pay tributes. I know this is about reasonableness, but can you expand on this?
Secretary, thank you for the comment. In general, such action will constitute worshipping. But then, of course, we have to look at each case on an individual basis, but we think that this is a breach of the requirements. Dr. Ho, any follow-up questions? No. I think that the administration should pay attention to this. People may try to circumvent the law. Mr. Tony Chair. Thank you, Madam Chair. I'd like to know more about 5A(c) Roman number 1. It talks about keeping a register. containing particulars on the matter specified in subsection 3. That's the register that the workshop has to keep. And in Roman number 2, it says that the operator of the workshop should keep copies of the relevant documents of the deceased person for at least 3 months after the date of removal of the ashes from the workshop. If you look at bracket 3, C is about descriptions of relevant documents of the deceased persons. Are we talking about the same kind of document which the workshops is required to keep for at least 3 months? Is there any document that the workshop don't have to keep for at least 3 months? Thank you. The documents are set out in 4. That is the permit to take away cremated ashes of the deceased person, and if the permit is not available, the certificate of cremation of the deceased person or any document that shows the identity and the source of the ashes of the deceased person. There is a definition. For Roman number 1 and 2, why do you have to draft it in such a way? Why don't you just ask the workshop to keep the register for at least 2 months? And why do you have to have a separate paragraph on the copies of the relevant documents of the deceased person? I will ask the DOJ to elaborate. Thank you. For the question, for Roman number 1, it's about register of the delivery of the ashes. For Roman number 2, they are copies of documents, and they have to be kept for at least 3 months. We're talking about 2 different things. What should be set out in the register? Is set out in Roman number 3. For Roman number 2, it's about documents that should be kept for at least 3 months. Mr. Chair, I don't really get it. You talked about register. They may not be copies. They could be true copy. And is that why you also set out the paragraph of Roman number 2? Why do you have to complicate things? Why don't you just ask the workshop to keep the records for 3 months? Mr. Look, thank you. For records or register, we're talking about entries of an incident. For documents, it's a separate thing. You have to keep copies of a document. For register, we're talking about the things that you write in a book. Deputy Secretary, let me give you an example. Say if deceased person named Chen Taiman, ID number 1234, under C1, you have to keep the name and the Hong Kong ID on the register, Chen Taiman 1234. For C2, we're asking the workshop to keep the copy of the identity card of the deceased persons, and it has to be kept for at least 3 months. Mr. Chair. For bracket 3, bracket C, descriptions of the relevant documents of the deceased persons. For Roman number 2, as the DOJ has explained, the workshop has to keep the copies of the documents, and the documents have to be kept for 3 months. For other register, they don't have to keep it for 3 months. They can just lose it. Am I right? Mr. Luck. Thank you, Madam Chair. Roman number 3 explained that the workshop must keep the register and make available the register for inspection on request by the director or an authorized officer. For copies of documents, they only have to keep it for 3 months. Madam Chair, to put it simply, the workshop has only to keep the copies of documents for 3 months. For other documents, they have to keep it forever. Am I right? Mr. Look. Thank you. We don't specify the period of time when the workshop have to keep the record for, but as long as the director asks for the information, they have to produce it. To put it simply, the workshop has to keep the register for an indefinite period of time. Is there any expiry date for keeping of documents in the laws? Is it the case that as long as you don't specify the period, the workshop has to keep the record forever? I think that's only natural. You should keep the records for ashes that have been placed in a workshop. The period is not specified in the bill. In other ordinances, there could be period specified for some other arrangement. As far as a workshop is a mason's workshop, they have to act in accordance with the law and keep the register. Madam Chair, one more question. Is there any penalty if the workshop loses the register? DOJ? Under this bill, we have not set any penalty for losing the register. But if the workshop becomes ineligible because they breaches too many requirements, then we will cancel the license. Thank you. Next, Mr. Paul Chair. I'd like to follow on the discussion. We're talking about 14 days. The target is mason's workshop. Staff there may be craftsmen, but they are not good with, say, administrative work. I know that there is no penalty or fine, but any violations may affect the license of the workshop. I think that the arrangement is too complicated. You ask the workshop to keep so much information in the register, and you have asked them to keep the documents for 3 months. The niches are only kept, or the ashes are only kept in the workshops for 14 days. And some descendants may try to, say, bow before the ashes once or twice. Is this a form of worshipping? I think that the restrictions is too rigid. It seems that you are carving on a rice. I think that we have to take a more relaxed approach. We should only target illegal sale of niches. Why set so many restrictions and regulations on masons' workshops? And this is why the members have so many comments to make. Thank you. The requirements for masons' workshops are existing ones, and we have only set that out under the bill so that they are not regulated under it. The masons' workshops are familiar with our existing regulations, and they are already keeping the register. Mr. Chair, I have already given my comment. My apologies. My instinct is that you are putting in place too strict regulations. We have only 5 minutes left. We have to extend the meeting by 15 minutes. I think that we should also cover part 6. 5A, any other questions? It's rather long. 1, 2, 3, 4. Bracket 4, any questions? And then we have some notes. Any questions? No? Part 6. Miss Ao, please. It's about section 15 and 16. There are technical amendments regarding company secretary. Under section 44, we ask the holder of specified instrument and applicant to notify the licensing board of any changes to the management. We are proposing to amend the reference of secretary to company secretary to align that with the definition of management under the company's ordinance. It will not affect the existing arrangement. Any questions? Clause 16. We are to amend section 100 bracket 1. It's about the liability of directors, partners, etc. for offenses. We change the word secretary to company secretary to make it consistent with the definition of senior management under the company ordinance. The existing arrangement has not been changed. Any questions? If not, if members would like to propose amendments to the bill, please submit the proposed amendment by 5 p.m. on the 7th of April 2025, Monday, to the Secretariat via email. The Secretariat will ask the administration to give a written reply regarding the amendment, and we are going to ask members if we are going to organize another meeting. So the deadline is 5 p.m., 7th of April. We have scrutinized the Chinese version. Mr. Benson Looks, press the button. Mr. Look. Thank you. Sorry, Madam Chair. I'd like to follow up on your suggestion. I know that the administration is going to look into the comments and views that we raised, but for the cases that we quoted, is the administration going to follow on it, and are you going to have a meeting? Perhaps from now until the 7th of April, let's see if we can arrange a meeting for the Columbaria who have submitted their written submissions. I hope that there will be a meeting before the deadline to make it more meaningful. Let's meet before the 7th of April to see if the stakeholders have any other views. Mr. Tony Che. Madam Chair, you said that we're going to organize another meeting. Are we going to meet with the stakeholders in the name of a Bills Committee? We're going to select a date to meet with the stakeholders. And we should let everyone know. I think that we should send an email to the interested parties. Are we going to organize a meeting in the name of a Bills Committee? Because the deadline for submitting submissions have passed. If we organize another meeting in the name of the Bills Committee, as far as I understand, this has never happened before. Because for open hearing or written submissions, there is a deadline. there were people who wanted to meet or make representations in Bills Committee meeting after the deadline. I believe that other Bills Committee did not allow it. So I'd like to clarify. So I don't think that we should organize another meeting in the name of the Bills Committee. That's my first point.
聽到好多
Second, we've all raised our views just now. Like the Deputy Secretary said, any changes would be supported or rejected by the stakeholders. So I think the government has already taken into consideration all the relevant factors, and I would respect their proposal. Now on the fee charged, can the government supplement to us the formula behind the fees calculation so that we can have a clearer look on how the exempted fee is calculated? Then we can have a better footing to say whether the arrangement is fair or not. So I agree with the third part of your view. We have put forward so many views, so I hope there would be a written reply from the government. Concerning the meetings arrangement, I don't think we would issue an invitation in the capacity of a Bills Committee. Now, the stakeholders would organize this meeting and invite council members and government officials to attend the meeting. That would be a meeting outside of the Bills Committee's purview, but I would offer help in terms of arranging the time and location of the meeting. Yes, thank you, Chairperson. I support this approach. Mr. Ambrose Lam. I support Mr. Tony Tse's proposal or suggestion and the decision made by the Chairperson. Now, the arrangement has been set and we have completed the process. If there are more views, stakeholders can submit written submission and the government will reply to these submissions. If some members are still dissatisfied with the proposal, they can move an amendment at the committee stage. Now, we have scrutinized the English text of the bill. Legal advisor, any views on the Chinese text? Thank you. Besides the inquiries we have made previously concerning the English text of the bill, from the legal and drafting point of view, we don't have any questions. Thank you. Any questions concerning the consistency between the Chinese and English text? So after receiving a member's CSA proposal, we will decide whether another meeting is needed. There is no AOB. The meeting is adjourned. Thank you.